Assalamualaikum and salam biru warna. My name is Siti Nurhaja binti Muhammad Mani and my matric number is 244221. So today, my group members and I would be presenting a case named Mariya Stephen or Fredolin Milis versus Guat. For your information, this is actually an appeal case at the Court of Appeal Putrajaya. The parties of the case are Guat as the plaintiff and also respondent. Meanwhile, Mariya Stephen is actually the defendant or appellant of the case. The facts of the case in the previous court, Guat was the plaintiff in the case, has brought an action against Mariya Stephen as the defendant for a civil litigation. The plaintiff in her action has asserted that the defendant has transferred her land under the document of title number NT0130900607 with the element of fraud. So, the respondent wanted to premise on a declaration and obtain relief from the case. In the plaintiff's statement of claim, she made an application for an injunction to restrain the appellant, her servants and agents from encroaching on the said property held on the document of title number NT013090607. The respondent wanted to be declared as the rightful owner of the property under Memorandum of Charge registered on 23 September 1991, 14 February 1997, 15 February 2002 to be declared as null and void. Not only that, the respondent has requested from the court to issue an order directing the Registrar of the Lands and Survey Department to cancel the endorsement of registered memo dated 23 September 1991, 14 February 1997, 15 February 2002 and another order that requires the appellant to return the said property to the respondent within 7 days. The respondent also made a request for damages of fraud to be assessed. However, on the day of the trial, the appellant, who was also the defendant, has requested for an adjournment of hearing because she was in the process of appointing new solicitors for her case. But the learned trial judge finds no reason to adjourn the hearing of the case, and so the request has been denied by the learned trial judge. And not only that, the learned trial judge has decided to proceed with the hearing. The decision made by the learned trial judge has led the appellant to submit no case to answer at the end of the respondent's case. And accordingly, the learned judge found merits from the evidence submitted by the respondent, and the judgment made was in favor of the plaintiff. But the defendant was not satisfied with the judgment by the court, and so he appealed against the decision. The appeal case has been heard by the court on 13 May 2013, but it was also dismissed on the same date because it was found that the appellant did not include the issue of adjournment in the memorandum of appeal. Therefore, the appellant has no right to raise the issue during the hearing of appeal. The appeal dismissed with cost of 5,000 ringgit to be paid by the appellant to the respondent. So, the issue of the case is whether the court has the right to deny the adjournment of hearing.
Hi, my name is Fatima Azara binti Rosli 248612. In this Mariya Stephen case, I will present to you regarding the contention by both parties. And in this case, there are two parties that we know as the appellant and also the respondent. In the previous case, the appellant act as the defendant while the respondent act as the plaintiff. So, Let us start with the contention by the appellant. In this case, the appellant had sought an adjournment on the ground of appointment of the new solicitor. However, the learned judge has denied the adjournment process with trial. Secondly, the appellant claims that the learned judge failed in his action to give sufficient judicial appreciation to the fact and issue of the case. Thirdly, the learned judge also stumbled in law when he allowed the respondent's case against the appellant. Next, the respondent also was premised as fraud, deception, and conspiracy beyond reasonable doubt. The learned judge also slipped up in law and be unsuccessful in giving the decision due to the weight or relevant considerations. And lastly, the judgment made by the learned judge was wrong and prejudiced. On behalf of the respondent claimed that the land was transferred wrongly by the appellant. Next, the appellant has not raised the issue of adjournment in the memorandum of appeal. Thirdly, there was no proper exercise of discretion by the judge to take into factual metrics of the case. And lastly, the respondent contended the assumption by the respondent when there is no response on behalf of the appellant to call the witness. Thus, she thinks there is no dispute arise.
Okay, good day everyone. Today, I'll be talking about the judgment made by the court regarding this case. My friend had presented the parts on the facts of the case, the issues, and as well as the contention made by the appellant and the respondent. So now it's my turn to talk about the judgment of the court regarding both the contention of both parties. Okay, regarding the issues, the court had decided to dismiss the appeal of the defendant, or also known as the appellant in this appeal case. In the grounds of their judgment, they referred to two decided cases as well as two provisions from two separate legal acts. The first reason is that the appellant chose to submit no case to answer, which is potentially fatal unless the plaintiff had not satisfied the legal burden according to law, or the plaintiff has no case or locus according to the law. This is referring to the case of Tor Eagle Maritime Agency versus Innovest Berhad, which has a similar issue. Okay, so in this case, in our case, the plaintiff, or in case the respondent, has satisfied the legal burden and has case or locus. Meanwhile, the appellant chose not to submit a case to answer, which is the court said that is potentially fatal given the standing the plaintiff has at the moment. The plaintiff had closed their cases and defendant does not call witness. This led to the court to assume that issues on fact is not in dispute, and that all the evidence led by the plaintiff must be assumed to be true. Okay, this is on the defendant's fault, and it refers to the case of Yuil versus Yuil held in 1945. And the court also referred to section 114 subsection G of the Evidence Act, which support that the plaintiff's case on facts when the appellant in this case does not call witness and submit no case to answer, and whether or not the court has cautioned the appellant. In both the Malaysian jurisprudence as well as the rules of court, the law also does not permit the defense to take lackadaisical attitude by not calling evidence. Okay, the issue here is about the issue of the dismissal of the ground is mostly related to the appellant not calling evidence and not submitting no case to answer. This is considered to be a lackadaisical attitude by the court. Consider that the appellant is taking a lackadaisical attitude in their appeal case, and furthermore, they also asked for an adjournment to the court. The ground of the adjournment was that they wanted to hire new solicitor to represent them. However, the judge refused the adjournment and decided to proceed with the trial. The reason for this refusal is because the matter of adjournment is within the discretion of the trial judge, and that an appellate court will not interfere with the refusal of adjournment unless it appears that the result of such a refusal has been to defeat the rights of an appellant altogether, or it is an injustice to such an applicant, which in this case the courts held that it is not, and personally I agree. Furthermore, the appellant had not raised the issue of adjournment in the memorandum of appeal, and in consequence, it was not proper to raise it during the hearing of appeal. Now, furthermore, taking into the factual matrix of the case, there was no improper exercise of discretion by the judge. So, in summary, the decision was the court dismissed the appeal and also refused the adjournment by the appellant. Okay, that is all for the decision. Now we will proceed with the analysis of the case.
Now we go to the analysis of this case, which after a thorough study of this case, we found that the dismissal made by the Judge of Court of Appeal is fair and justified. We have analyzed a few matters regarding the judgment of the court. The first matter is regarding the application for adjournment on the ground of the appointment new solicitor made by the appellant has been denied at trial court. We found that the denial was reasonable as the trial court succeeded to appreciate its discretion by considering two important matters, which are the legitimate reason on the application of adjournment and the impact on the person applying the adjournment. In our view, the state court has exercised its discretion properly as according to the interest of justice because it was unreasonable to adjourn the hearing just because the appellant was in the process of appointing new solicitor for her case. So the next matter that we have analyzed is regarding the power of the Court of Appeal to interfere in the previous matter. So from the case of Dato Muhammad Pilus bin Yusuf ex parte Senior Berhad, it is crucial for us to highlight that an appellate court will not interfere with a refusal for adjournment made in the trial court unless it is exposed to breach of natural justice, which all parties has the right to a fair hearing. In this case, since there was no improper exercise by the previous court, and there was a failure on the appellant to raise the issue in the memorandum of appeal, we cannot deny the fact that the appellant, the appeal court cannot further terminate. Okay, the third matter that we have analyzed is regarding the failure by the appellant to call any witness and submit no case has directly breached to the presumption of adverse inference under Section 114G of Evidence Act 1950. Another case that's supporting this situation is Munusami Venga Dasalam against public prosecutor, whereby explained that an adverse inference can be drawn from withholding not just any document, but material document by a party in his possession, or for non-production of not just any witness, but an important and material witness to the case. So by that we agree that it is a tried law and a fundamental tenet of the rule of law that whoever alleged fact must produce the necessary evidence in proof of such facts. The court has gone through the notes of evidence and also the relevant document issued by both parties. We can conclude that from the case, it displays no merit in the appellant's complaint. Therefore, we agree to the court decision that the failure will be fatal unless the plaintiff has not satisfied the legal burden or has no case or locus according to the law. Obviously, all the evidence lead by the plaintiff must be assumed to be true. In a nutshell, from all the things that we have analyzed, we can say that the fact that the civil procedure law plays an important role in convincing the court to decide cases in a fair and uniform manner. It cannot be denied, as the finding of the case shows the appreciation by the court of the procedural as whole. Thank you.